Good evening. As we navigate the complex landscape of 2026, a singular heavy question has begun to dominate the conversation in immigrant communities across the United States. For those who have worked, waited, and finally sworn the oath of allegiance, is their status truly secure? We are currently witnessing an era where immigration enforcement has shifted into a much higher gear, becoming louder, faster, and more technologically aggressive than at any point in recent memory. In this new climate, files that have gathered dust for decades are being pulled from deep archives, and background histories are being digitally cross-checked against global databases in the blink of an eye. On social media platforms and encrypted group chats, the atmosphere is thick with apprehension. Rumors of mass citizenship cancellations are circulating rapidly, fueled by dramatic headlines that often prioritize clicks over context. This collective anxiety is real, and for many naturalized citizens, it feels as though the very foundation of their American life is under scrutiny. However, in times of high emotion, fear often outpaces the facts. Before we allow panic to fill in the blanks, we must pause and examine the structural reality of our legal system. What has actually changed in the wake of the 2026 policy shifts? What is legally permissible under the United States Constitution? And who, if anyone, is genuinely at risk of losing their citizenship? There is a profound divide between political rhetoric and constitutional law. Understanding this distinction is the critical difference between living in a state of unnecessary fear and moving forward with informed confidence. Today, we begin our deep dive into the 2026 enforcement landscape to provide the clarity and power that only facts can offer. Defining the mission, clarity over chaos. In this complex era, navigating immigration policy requires more than just reading headlines. It requires a deep understanding of the legal structures that protect your status. I'm Sophia, and my mission is to dismantle the noise and replace it with actionable intelligence. In 2026, the landscape of enforcement has shifted, but the fundamental pillars of American law remain a critical shield for those who know how to use them. Today, we are moving beyond the surface-level anxiety to unpack exactly what is happening behind the scenes of the current administration's enforcement surge. We will explore the technical definition of denaturalization, a word that is often misused in public discourse. We will analyze why older citizenship files are suddenly being pulled from the archives and who is actually being targeted by federal investigators. Most importantly, we will outline your constitutional rights and the practical steps you should be taking right now to safeguard your future. This discussion is not about the shifting winds of politics. It is about the unwavering reality of legal process, evidence, and facts. When enforcement intensity reaches its peak, clarity becomes your greatest power. By the end of this analysis, you will have a clear roadmap to distinguish between legitimate legal scrutiny and the unfounded rumors that often dominate social media. Let's begin by separating the law itself from the aggressive methods currently being used to enforce it. The 2026 shift, policy and priority. To comprehend the current state of affairs, we must look back to the political shifts of early 2025. Upon returning to office, the Trump administration immediately identified immigration enforcement as its central priority, setting the stage for the aggressive landscape we see today. Executive directives have since pivoted toward a policy of stricter compliance, which essentially means a zero-tolerance approach to past errors. This isn't just rhetoric. It has manifested in the form of expanded fraud detection units and massive deep-dive audits of decades-old immigration records. By the start of 2026, federal agencies began receiving unprecedented levels of funding for personnel and digital infrastructure specifically dedicated to reviewing naturalization histories. The focus is laser-sharp. They are looking for inconsistencies, criminal omissions, or any form of suspected misrepresentation that may have occurred during the original application process. This surge in government attention is what has fueled the current wave of anxiety. However, a crucial distinction must be made. While the intensity of enforcement has skyrocketed, the law governing citizenship itself has not fundamentally changed. There is no new law that makes it easier to cancel your status, nor is there an executive order that allows for the administrative revocation of citizenship at the press of a button. In the United States, citizenship remains a status protected by the Constitution, meaning it cannot be handled casually or through a simple internal agency decision. Understanding this boundary is vital for every naturalized citizen. The legal fortress. The court requirement. As we dig deeper into the 2026 enforcement framework, we must address the single most important legal safeguard, the requirement of a federal lawsuit. Despite the aggressive tone of current policy, there is no such thing as a secret or instant citizenship cancellation. The process of denaturalization is a long-standing legal mechanism that has existed for decades, and it is governed by very strict federal laws. The government cannot simply send you a letter saying your citizenship is gone. To revoke your status, the Department of Justice must file a formal civil lawsuit against you in a United States federal court. This is the nuance that often gets lost in the noise of group chats and viral warnings. A federal court case means that the government carries the heavy burden of proof. They cannot rely on suspicion or vague digital flags. They must present clear and convincing evidence, a very high legal standard, before an impartial judge. Most importantly, as a naturalized citizen, you have the absolute right to defend yourself. You have the right to legal counsel, the right to cross-examine evidence, and the right to present your own story. There are no shortcuts for the government here. Without a judge's final ruling in a federal court, there is no denaturalization. This legal structure remains the ultimate fortress for naturalized citizens in 2026. While the technology for finding discrepancies has advanced, the courtroom remains the only place where those discrepancies can be turned into a legal judgment. Your status isn't at the mercy of an agency employee. It is protected by the judicial branch of the government. Technology as a tool, the digital audit. The real shift in 2026 isn't the law, it's the technology. We are now seeing the full implementation of advanced digital cross-check systems that were unimaginable just a decade ago. Federal agencies have undergone a massive modernization effort, scanning millions of paper archives and integrating them into searchable, AI-driven databases. This means that an application you filed 15, 20, or even 30 years ago is no longer buried in a dusty warehouse in Nebraska or Missouri. It is now a digital file that can be cross-referenced in seconds. These systems are designed to flag discrepancies across a person's entire immigration lifecycle. Your original visa application, your asylum filings, your travel records, and even foreign criminal databases are now talking to each other. If you used a slightly different name on a visa entry in 1995 than you did on your naturalization form in 2010, the system will flag it. If a criminal record from another state or country was missed during your initial background check, it will likely surface now. But here is the most critical distinction for 2026. A digital flag is not a revocation. An alert on a federal agent's screen is merely a starting point for an investigation. It is not a court judgment. For the vast majority of naturalized citizens, those who were honest, met the requirements, and had no disqualifying issues at the time of their application, this technological surge does not equate to danger. Thoroughness is not the same as a legal threat, provided your foundation was built on the truth. The target. Who is under the microscope? To address the rumors head-on, we must answer the most pressing question. Who is actually at risk of a denaturalization review in 2026? Despite what you might see in sensationalist headlines, the government is not conducting broad sweeps of entire nationalities or targeting people simply because of when they immigrated. The focus is much more technical and highly specific. Federal enforcement is currently concentrated on one fundamental question. Was your citizenship lawfully obtained at the very moment it was granted? This distinction is the key to everything. Denaturalization does not focus on what you have done since becoming a citizen. It is not about your political views, your current lifestyle, or minor mistakes made as a citizen. It centers entirely on whether there was fraud, concealment, or material misrepresentation during the original immigration or naturalization process. Investigators are looking for the original sin in the application. Was there a serious criminal history that should have blocked your approval? Did you hide a previous deportation order or use a false identity to gain entry? These are the specific categories being scrutinized. For the average person who lived by the rules, paid their taxes, and was honest with the government, the current microscope of enforcement should not be a cause for alarm. The law is looking for specific, intentional deception that undermine the integrity of the naturalization system. By understanding that the focus is on the past application, not the present citizen, we can begin to see the limits of these investigations. The criminal element, undisclosed history. One of the primary categories receiving intense scrutiny in 2026 involves individuals who allegedly failed to disclose a serious criminal history that existed before they naturalized. We must be very precise here. The keyword is serious. In the current enforcement climate, investigators are not wasting federal resources on forgotten parking tickets or minor traffic citations from 20 years ago. The law is looking for undisclosed arrests, convictions, or specific criminal conduct that, had it been known at the time, would have legally blocked the approval of the naturalization application. This typically includes crimes involving moral turpitude, drug trafficking, or violent offenses that would have prevented the applicant from meeting the good moral character requirement. The 2026 digital systems are exceptionally good at finding these ghosts from the past. For example, a conviction in a different state under a slightly different name might have been missed in the 1990s, but today's interconnected databases will flag it almost instantly. If that offense was omitted from the N400 application, the government may argue that the citizenship was obtained through concealment of a material fact. However, it is important to remember that the government must still prove that the omission was intentional and that the crime itself was significant enough to have changed the outcome of the case. For those who have lived law-abiding lives both before and after their naturalization, this category of review remains a very narrow threat targeting a specific group of individuals. Identity and marriage fraud, the foundation of status. The second major category of scrutiny in 2026 involves identity inconsistencies and marriage-based fraud. In our current digital age, it has become much easier for federal agencies to track the biographical trail of an immigrant from their very first visa application to their final citizenship ceremony. Investigators are looking for situations where different names, dates of birth, or family histories appear across various filings, such as asylum claims, green card petitions, and foreign records. While some of these inconsistencies are innocent clerical errors, others raise red flags about intentional identity concealment. Similarly, marriage-based green card cases are being re-examined where there is strong suspicion of a sham marriage. The legal theory here is simple. If the permanent residency, the green card, was obtained through fraud, then the citizenship that followed it was built on a faulty foundation. In 2026, the government is using Social Security data, travel patterns, and even old housing records to look for signs that a marriage was never legitimate. However, these cases are notoriously difficult for the government to prove decades later. Intent is the central battlefield in court. Was the discrepancy a mistake by a translator? Was the marriage a genuine partnership that simply failed? The government must provide convincing proof of fraud, not just a failed relationship. For naturalized citizens whose journeys were based on real relationships and honest identities, the noise of these investigations is often much louder than the actual legal risk. The power of materiality, typos versus fraud. Perhaps the most critical concept for every naturalized citizen to understand in 2026 is the legal standard of materiality. In the world of immigration law, not every mistake is a crime, and not every omission is fraud. For the government to successfully denaturalize someone, they must prove that any misrepresentation was material. This word carries enormous legal weight. A material fact is one that is so significant that, had the truth been known at the time of the application, the citizenship would not have been granted. This means that minor errors, the human mistakes, are generally not enough to strip someone of their status. A typo on your home address from 1992 is not material. A short, forgotten trip to visit a sick relative abroad that lasted 2 weeks is not material. A minor offense that did not legally affect your eligibility is not material. The government's burden is to show that your alleged concealment actually mattered to the outcome of your case. This is a very high bar to clear in a federal court. Defense attorneys in 2026 are frequently winning cases by demonstrating that even if a client made a mistake, that mistake had zero impact on their legal right to become a citizen. By understanding the materiality standard, you can begin to see why the rumors of mass cancellations are often exaggerated. The law requires a level of significance that a simple clerical error just doesn't meet. Your day in court, due process rights. If you are ever contacted by a federal agency regarding your naturalization, the most important thing to remember is that you are not alone, and you are not without power. In 2026, the United States Constitution still guarantees you due process. This means the government cannot simply cancel your citizenship administratively or through an internal memo. They must file a civil lawsuit in federal court, and that is only the first step in a long, structured process. As a defendant in a denaturalization case, you have a suite of fundamental rights. You have the right to be served with a formal notice. You have the right to hire an attorney to represent your interests. You have the right to review every single piece of evidence the government has collected against you. Nothing can be hidden in secret files. You have the right to challenge that evidence, call your own witnesses, and present your own defense. Furthermore, the burden of proof is entirely on the government. You do not have to prove you deserve to be a citizen. The government must prove with clear and convincing evidence that you were never legally entitled to it in the first place. This is a civil proceeding, not a criminal one, which offers a different set of procedural protections. However, because fraud allegations can sometimes lead to parallel criminal charges, having early legal representation is not just a right, it is a critical strategy for your protection. Handling the unexpected, contact and conduct. In the 2026 enforcement environment, it is possible, though statistically unlikely for most, that you might be contacted informally by federal investigators. This could come in the form of a letter requesting additional information about your past, or even an unexpected visit to your home or workplace. In these moments, your conduct and your knowledge of your rights are your best defenses. It is crucial to understand that you are not required to answer detailed questions or provide a statement on the spot without legal counsel present. You can and should remain calm and polite. You can state clearly, "I wish to consult with my attorney before responding to your questions." This is not an admission of guilt. It is the exercise of a constitutional protection that every person in the United States possesses. Furthermore, silence is not a legal admission. Taking the time to get expert guidance ensures that you don't accidentally provide inaccurate information due to stress or a faulty memory of events from decades ago. Additionally, the American judicial system provides the right to appeal. If a lower court were to rule against you, the process doesn't end there. Higher courts exist to ensure that the law was applied correctly and that your constitutional safeguards were respected. The system includes protections against the abuse of process, meaning the government cannot endlessly harass you without new, significant evidence. Stability comes from knowing that the law has built-in brakes to prevent overreach. Busting the myths, mass deportation, and loyalty. In times of high political tension, misinformation becomes a wildfire. In 2026, several damaging myths are circulating through immigrant communities, and it is time to dismantle them with facts. The most prominent rumor is the claim of mass deportations of naturalized citizens. This is simply not happening. Denaturalization cases remain a very tiny fraction of the millions of citizens in the U.S. These are highly individualized legal actions based on specific fraud, not broad, community-wide sweeps. The word mass is often used to generate clicks, but it does not reflect the legal reality of 2026. Another common myth suggests that traveling to your country of origin, speaking your native language, or holding dual citizenship puts your status at risk. This is entirely false. The United States does not require cultural abandonment. You are free to maintain ties to your heritage, visit family abroad, and speak any language you choose. Citizenship is a legal status, not a cultural loyalty test. Unless your country of origin specifically forbids it, dual citizenship is generally permitted under U.S. law. Furthermore, some fear that because interview standards have become more detailed for new applicants in 2026, current citizens will be called back for retesting. This is not how the system operates. Once you are naturalized, you are not routinely re-interviewed unless a specific investigative trigger is found in your original file. Your citizenship is a permanent status, not a temporary permit that needs constant renewal. Crimes after citizenship. The legal distinction. One of the most misunderstood areas of immigration law in 2026 is the impact of criminal conduct after naturalization. Let's be very clear. Once you are a naturalized U.S. citizen, you are generally subject to the same laws as a native-born citizen. If a citizen commits a crime, they are processed through the criminal justice system. They may face fines or prison, but they are not subject to deportation. Deportation is a consequence that applies to non-citizens. The only way a citizen can be deported is if their citizenship is first revoked through the federal court process we've discussed. This only happens if the government can prove that the citizenship was obtained through fraud in the first place. Therefore, the timing is everything. Criminal conduct only becomes relevant to denaturalization if it existed before you became a citizen and was concealed during the application. If you have been a citizen for 10 years and then receive a DUI or are involved in a legal dispute, that does not trigger a denaturalization case. The focus of the 2026 enforcement surge remains squarely on whether the foundation of your citizenship was lawful at the time it was built, not on mistakes made years later as a citizen. Understanding this distinction is vital to eliminating the fear that any legal trouble automatically leads to the loss of your American life. Practical steps. Preparation as power. While the legal protections for citizens are strong, the high-intensity enforcement of 2026 means that preparation is more important than ever. We are moving from a state of panic to a state of preparation. The first and most practical step you can take is organization. You should have a secure immigration file that includes copies of your naturalization certificate, your old green card records, and every application you ever submitted to the government, including supporting documents. Maintain both digital backups and physical copies stored in a fireproof safe. Documentation is your strongest ally if a question ever arises. Second, if you know your immigration history was complex, perhaps you had prior overstays, name variations, or multiple filings, consider scheduling a confidential review with an experienced immigration attorney. This isn't because you are in danger, it's because clarity eliminates uncertainty. A proactive review allows you to understand any potential flags before the government does. Third, always respond promptly to official correspondence. If you receive a letter from a federal agency, do not ignore it or assume it's a mistake. Silence does not resolve legal questions, it often complicates them. Early legal guidance can prevent a minor clarification from escalating into a larger issue. For green card holders watching this, remember that your status is more vulnerable than a citizen's. Avoid criminal conduct, file your taxes consistently, and apply for citizenship as soon as you are eligible to gain that full constitutional shield. Conclusion: stability in a shifting world. As we conclude our analysis of the 2026 landscape, let us ground ourselves in the big picture. Immigration policy in the United States has always moved in cycles, expanding and contracting with the political winds. While the current administration has ushered in an era of unprecedented enforcement and technological auditing, the fundamental system of checks and balances remains active. The executive branch has authority, but the courts impose standards. Policy may shift, but due process still governs the final outcome. Technology has indeed made the world smaller and historical inconsistencies easier to detect. That is a reality we must accept. However, constitutional safeguards are just as real. Knowledge is the ultimate stabilizer in an environment that feels uncertain. If you are honest in your journey to citizenship, you are standing on the strongest legal foundation this country offers. Millions of naturalized citizens continue to live, work, build businesses, and raise families every day, contributing to the very fabric of the American story. Do not let the headlines drown out your confidence. Stay informed from reliable sources, stay organized with your records, and move forward with the power that comes from knowing the law. Your citizenship is not just a piece of paper, it is a structural protection and a testament to your place in this nation. Thank you for joining me for this deep dive. Stay prepared, stay confident, and remember, facts will always be more powerful than fear.